feet.
Here we go. Okay, I learned that for a lease to be valid and legal, it has to have three constants. It has to include location, amount of or consideration, and the length of the lease.
For it to be valid?
I think those are some basic elements. You know, there's no specific requirement. But
It could still be valid without those. Those are things that we think should be in a lease.
Without the length?
Well,
without the consideration?
Yeah, because with a verbal lease doesn't have any of that.
Okay.
It's just a verbal lease. It says you're renting from me.
Right.
Pay me.
Okay, well.
So we don't agree with that.
Well.
Yeah. We think a lease should include those things, but it doesn't need those things.
The agreement has to include those things, but the lease should include it.
Trying to put it together in my head, but a landlord that asks for anything that's extraneous, once that is shown in court, it could be seen as unconscionable. Is that what you guys said?
No. What do you mean by extraneous?
I think you guys said $2,000 for a light bulb.
Right, like something unconscionable.
Unconscionable, what did I say?
Unconscionable.
Yeah, that would have specific meaning in the law.
Right.
Okay, unconscionable.
Yeah.
So I myself am a property manager.
Sorry?
And I myself am a property manager. And I learned today, because I use the FAR's research, right? On simplicity. And when I thought I had a really good grab on it, I obviously didn't, because I learned tonight that a lease it's neutral in the sense of the liabilities of the landlord. So unless it's stipulated directly in writing, you know, the landlord is, for example, not liable for pest controls or...
No, but liable is the wrong word.
Okay, responsible?
Liable is like when you cause something responsible. Right?
Responsible,
I like that, yeah. I mean, remember, the lease is like a starting point.
So we assumed responsibility for like pest control, well not pest control, but like in the case of an AC breaking down.
And so you're saying you learned that you could shift that responsibility.
Yes, I didn't know that.
See, knowledge is power.
Knowledge is money.
That's money, yeah.
I like that. That is money. Yeah, that's good.
But the landlord's obligations to maintain properties in the reasonable conditions, like the toilet, or not to have if the tenant did something unreasonable, the landlord is not responsible to fix it.
Right. That's exactly right. Good. Anitra.
About the oral agreement, some people didn't know that it can stand in the court, the oral agreement, but apparently that's.
We don't recommend it.
Sure, right. But I didn't know you can go in the court with an oral
Absolutely.
In leases, unlike in home ownership, there aren't a rescission period or a 3-day notice. And
there isn't a rescission day in home ownership either from a buyer to a seller. Only condos. In mortgages maybe, but not in buying and selling.
Okay. And yeah, basically, if you're looking for late fees or things like that, as the owner of the property, included an additional rent so that they'll come back to you at some point in the future after an eviction process goes forward.
I learned that in Chapter 83, Section 51, there are two parts. The first part is something that the landlord must comply, and the second part is something that, unless otherwise agreed in writing, the landlord is not liable for, responsible for.
But I think I disagree with that. I think the landlord is still responsible. It's still a must, but they can be shifted if we put it in writing. The landlord can shift responsibility for like pest control. But they're both must. They're both must. But the second one has that unless otherwise.
The other's kind of like you must do it unless you shift it over.
Right.
Right. Yeah. Unless right.
And what's the other difference while you're talking about this? Because there was a difference between those two when you're talking about what rights the tenant has.
Yeah.
Like we talked about if the tenant wants to give that 7-day notice saying, you're in violation of my
We talked
agreement.
about it really fast.
We
so
did, we
we'll
covered
we'll
it
go
really,
over that.
okay.
But you can,
Yeah.
you can terminate the lease if the.
For the
if
number, for the
landlord,
one,
Yeah, fails to respond within 7 days
Right.
of receipt of the lease.
but just for the material
Just
things.
for the material.
You
Agreed.
got it.
Thank you.
Chapter 83.67 states, it specifies what landlords are prohibited of practicing, such as not allowing a tenant to display a U.S. flag,
Good
which
one,
is
I like that.
0.4. It has to be less than 0.4 feet, I think it is,
Right,
4.5 feet.
right.
I learned that a landlord can't shut off the utilities because actually in our last class for commercial leases, that was in the lease that they could do that to the tenant. So that's interesting to see the comparison.
Right. Big difference.
Yeah.
So,
shut.
me
I got
or
it right
shut.
this time.
In Florida, eviction cases can go to jury trial.
They could,
Yes.
yeah.
And it happens. Not often, but it does happen. Yeah.
What I learned is if landlord want to change or cancel the contract, he must notice the payment, 7 days for at least 7 days for
And the
weekly
landlord
payments.
wants- Well,
We haven't learned that yet.
we haven't learned it yet.
But we already talked about that.
Not yet. We'll talk about it more.
Okay.
Anything else to learn?
The landlord will pay for any reasonable condition.
The landlord will have to provide reasonable conditions,
Yeah.
right?
But I believe they were they are concerned about, for example, if something didn't write in the contract, they won't do that.
Or something like?
They didn't write in the contract.
Oh, if they didn't say that they would provide it in the contract, and they don't, not required to provide it by law, by statute, then they won't provide it, right?
I learned that a party can't just write unreasonable stuff on a lease because it might be considered unconscionable.
Right. They can write it, it's just not gonna be enforced.
And not in court, right?
As a tenant, if I pay for a repair, that one is not deducted for.
Right, you can't deduct it from the rent. Exactly right. I learned, and I was so surprised that in Florida it's not mandatory to have air conditioning.
Right, it's not in the statute, it's not required. Landlord does not have to provide it.
Wow.
Crazy.
So we only have about half an hour, so we
Okay.
have to go over there,
Not
so
a
I'm at
problem.
9:30.
What's the most
So
important
I
stuff
think
going
we
to
should
cover?
do the calendar,
Okay, great.
and then we can see if we can pick up anything else.
Okay,
Yeah.
great. So we're gonna talk about the eviction process.
So we're gonna talk about the eviction process, and I need somebody to come up and help write on the board. Who wants to do that? Daniel. Now, I think it's, I always said that people who sit on the front would participate the most. It just happens that way. Now that Daniel's in Ross's seat, he's participating.
That's what it is.
Yeah, that's what it is. Ross is watching, so. He is. Ross and Anna Lee.
That seat, right?
Yeah. Here. Oh, you got one. Okay.
Seat there.
So let's say we're gonna give an example of an eviction. Let's say who wants to be our bad tenant? Who can handle it? And it has, okay, Debbie. So I want you to read this again because you're gonna be this guy. Okay. Oh, he wasn't here when we read it. So he doesn't know what it is. Yeah.
Oh, that guy is heinous.
I knew my rent was going to be late about a week ago. I worked my ass off, but I still can't pay it though. But I got just enough to get up in this club, have me a good time before my time is up. Hey, let's get it now.
Alright, we're gonna see why our tenant, I'm gonna call him Tommy the tenant. I like to make it alliterary so it's easy to remember. So Tommy the tenant entered into a 12-month lease, and that lease started on, when should we have it? September 1st?
Sure.
It started September 1st, so we'll just put September 1st, and it was going to go September 1st, 2016 through August 31st, 2016. 17, you're right. So, and he's paying $1,000 a month for rent. And he paid on September 1st, he paid the rent of $1,000 a month. So we're gonna start making, our timeline's gonna go like horizontal.
Yeah.
Yeah.
With our timeline?
Yeah.
Make an amortization table.
With timeline?
Oh, okay.
No, I mean, you don't have to do that. Like, just go all the way to the left and write September 1st. Like, as far left as you can get.
Yeah.
Okay. So September 1st, Tommy the tenant, he's doing a good job. He paid $1,000 for rent, right? Put $1,000 under him.
Under Tommy?
Under September 1st.
Okay.
Okay. And he also paid a security deposit of $1,000. So put a security deposit of $1,000.
Oh.
For people watching online, he's just putting it under there.
His boss
Okay.
would be so
So
mad.
now go a little bit to your right and put October 1st.
Oh my god, this is so messed up.
So on October 1st, Tommy the tenant paid $1,000 for his rent. Okay. And on November 1st, Tommy knew his rent was going to be late a week ago. So he didn't pay anything. It's already, what day are we at now?
Now reverse.
Oh, the 8th.
Will his landlord have done something before that or not?
3-day notice.
Yeah, I mean,
Okay.
yeah, somebody already mentioned, I heard 3 days notice.
Okay, so November 1st, Tommy knew his rent was gonna be late a week ago, and he didn't pay it. So he knew around October 27th that his rent was gonna be late. And in this song, or what Tommy just read to us, he didn't say, and he told the landlord. He didn't. So he knew his rent was gonna be late, and he just went to the club. He is not worried.
Straight up.
And we're gonna learn why in Florida he wasn't worried. So November 1st he didn't pay the rent.
15 days, doesn't it?
No.
Or 7 days.
No, let's see. November 1st he didn't pay the rent. In Florida, is there a grace period?
No, unless
I was asking the students.
Oh.
There's no grace period. So when is his rent rate? His rent late.
November 2nd.
Yeah, his rent is late November 2nd.
But doesn't that depend on the lease?
It depends on the lease.
Yeah,
If the lease gives a grace period, then there is. But why would a landlord give a grace period?
I mean, don't you have the tenancies at will?
What?
The tenancies at will, like it's period to period, so it's like a week to week, 6 or 7
No,
days.
this is a yearly lease.
We're
So
not
this
yet.
lease says that the rent's due on the 1st. So he doesn't pay November 1st. What day is November 1st? What day of the week?
Monday.
Is it?
No.
No, it makes a difference. November 1st is a Tuesday. So he didn't pay on November 1st. But you can't be close when we're talking about real estate law.
No, I know.
No, you really can't be, especially when we're talking about landlord-tenant law. Close won't cut it. Close will let you get all the way to court and get you thrown out. So we're going to learn why. So Tuesday, November 1st, he doesn't pay. So who wants to be the landlord here?
Me.
Okay, Pedro, you're the landlord.
Of course.
So Tommy the tenant has paid the last 2 months. November 1st, he doesn't pay. What should the landlord do?
Send him
Send a letter.
send a letter.
What should the letter say?
You missed payment, it will due November 1st.
So friendly reminder.
You want to be friendly?
No, you want to be firm, but yeah, you don't want to show, basically you don't want to.
Wait, no, I want to hear what he doesn't want to do. What don't you want to do?
Well, you don't want to sound too rough on that letter. It's just a reminder. It has to be professional. It doesn't have to be.
Well, it's actually a statutory notice, and you don't have to be friendly in it. You just have to write the language that the statute requires.
Right, but not with threats or of any kind, right?
No, it has to say the same language.
Right, that's what I'm saying.
No, you said to send a friendly notice. There's nothing friendly about that
It's a
notice.
friendly reminder.
There's nothing. A friendly reminder is not.
Right, don't take my words.
No, but I am taking your words,
Okay.
because a friendly reminder does not start the process that this notice starts. If you send it, let's say you start, okay, let's say we did it, let's say we sent a friendly reminder, what day?
The second.
Okay.
I mean, that's, again, most landlords, I mean, some are right on it, but, maybe they think they're gonna pay, maybe,
So,
all right, he's a day or two late, I'm busy, I'll deal with it.
alright, no, but let's say you send a friendly reminder, what day?
On the second.
No, you probably wouldn't send it the second, especially if you're being so
But
friendly.
he's a new tenant, you're being friendly. We've
So
already
you probably
established
send it
that.
on the 4th. You probably send it on November 4th, which is a Friday.
And it's a friendly letter, forget what's on the
Right.
screen here.
So it's great.
It's just a.
No, please stop talking.
Sorry.
So Friday, November 4th, you still haven't, Tommy the tenant still hasn't paid. And I'm gonna let you not be the landlord. What's your first name again?
Alex.
Alex is the landlord. He's so friendly. So Alex, you send your friendly letter on November 4th. Okay. And what does it say?
Mr. Tommy, I would like to remind you that your rent was due on November 1st, and please. Of course he knows.
And this, what did he say? Tell me what you said, Tommy.
I knew my rent was gonna be late about a week ago.
So he knew. So you think he needs a friendship reminder?
This is not really for him, this is for the record.
Okay. Okay, we'll see what this, so let's say he gets you a friendly reminder and he says.
What we're trying to
Right,
accomplish
so
here is due diligence,
this is
right?
what I would say if I got your friendly reminder. I'm gonna go to the club and have a good time.
I worked my ass off.
No, that's not what I would say. I would say my landlord sent me a friendly reminder. I'm gonna go to the club and have a good time.
Right.
Before my time is up. Why would I do that if you send me a friendly reminder?
But this is not to enter into a struggle with the tenant right there and then. This is just for us to have some sort of proof before a court.
Okay, so let's say he
When the-
doesn't.
when the day
okay,
comes.
I understand what you're saying.
Uh-huh.
But let's say that he doesn't pay Friday, Saturday, Sunday pass.
Right.
And then let's say he doesn't respond to that friendly reminder. What would you do next?
Then you move on to the next phase, which
What
is
date?
Monday the 7th.
So
That's 7 or
Okay.
6?
So Monday the 7th, you would you check the mail, but the mail doesn't come on Sunday. So
Right.
you're not gonna wait till Tuesday?
No, I probably wouldn't.
Okay, Monday the 7th, what are you gonna do on Monday the 7th?
I'm gonna start a process for eviction.
How?
Well, you hire an attorney, just like
Call me.
yeah.
But actually, you don't need to hire an
You don't
attorney
need to.
for
Okay,
the
well you
first
can go to
step.
court.
You should.
No, you don't need to go to court for the first step.
I write a letter.
With that.
3-day notice.
7-day notice.
So you
No,
no.
there's a
Well, you
3.
wanna give me a notice, but I'll
We don't know now.
Okay.
Because this sort of legal documents have to go through
No,
an
a
attorney or
3-day
law firm.
notice does not have to go through a law firm. So what you're gonna do, because you waited on Monday the 7th, because you were being friendly on Monday the 7th. No, leave the 14th. He sent the friendly notice on the 7th. He sent the friendly notice on the 4th. And then on Monday the 7th,
So was the notice on the Friday? Or?
no, it's his friendly note. He sent a friendly note. Maybe put it on like stationery with some flowers or something. You want to be
I've
nice.
seen
Hey,
those
you
like
can do that, why not?
all the
Why
time.
not?
It happens, that's not an
Yeah,
unusual
okay.
thing to do.
So on Monday, the 7th, what's he gonna do? You're not allowed to break your tenant's legs.
I had a question about that.
What?
I was researching our president-elect. He used to say that,
No, this isn't part of the timeline. No, we need to get through the timeline. We're never going to do this tonight.
Okay.
Save your question. On Monday the 7th, what are we doing?
3-day notice.
3-day notice. So write it down. 3-day notice. And what does a 3-day notice mean? No, landlord, what does it mean?
That they have three days to either pay or get out of the property.
So if he doesn't pay, by when does he have to get out?
By Friday. What
Let's
day
look
is
at
it?
the days. Let's look at the days.
Thursday.
No, look at the dates. So Monday's the 7th.
Okay,
So
so
you're saying-
Thursday the 10th.
Right, so you don't count the day that you post a
Right.
notice. It can be posted on the door. So 8, 9, 10. So you're saying what has to happen on the 10th?
On the 10th is that I have a check, or you have to empty the premises and turn the keys in.
That would be nice, but then he wouldn't be so not worried. He would not be up in the club partying. That's not what it means. What it means is that on Friday the 11th, because you have to wait until the 3rd day expires, you can keep November 10th because that was the expiration. Thursday, November 10th was at 5 was the expiration of the 3-day notice. On Friday the 10th, after the 3-day notice expires, you are allowed, as the owner of the property, through a lawyer if you're in an LLC or a corporation, to file a complaint for eviction. So you have to let the 3-day notice expire before you're even allowed to file a complaint for eviction. Your friendly notice didn't start the days.
Of course, yeah.
So now, do they normally file it on Friday the 11th?
Well, I mean, if they're on the ball, they are, but they may not. I mean, it may take a couple of days. They may, it may not happen until the following week.
So let's say he's filing it on November
14th?
Well, that was 11th, is Friday. Let's say he files it on Tuesday, November 15th.
Okay.
So you filed a complaint for eviction on Tuesday, November 15th. What's Tommy the tenant doing?
Party.
Why?
She doesn't care.
What interest in property did you give him? What property stick did you give him?
Possession.
Yeah.
You gave him the right of possession.
Right.
He's waving in the air like he just doesn't care.
Right.
Because he knows that you have to go through the judicial process set forth in the Florida statute.
Right. Yeah, you just can come out and mace them and get
But you
them out.
told me you could kick him out. You'd have to do that on the 10th. You told me if you gave him the 3-day notice, he'd have to have everything out on the 10th.
Well, that's what basically what the notice says, right?
Well, then, yeah, sure, the notice says that you either pay or vacate, but if he's too busy out of the club, he's
Right, of course, yeah.
For what?
I mean, one thing is
But
what
legally, he doesn't have to vacate.
we know that most people in that scenario will take it as
But you
far
told
as
me you
possible.
were just going to pick up and leave.
Well, that's what ideally will happen.
That's
Right?
not what's going to happen.
Well, we don't know that.
We do know that. We know that.
Okay.
My concern is that you're fighting me on it, but it shows me you didn't read the readings. Because the readings would show you that that is not what's going to happen.
Yeah. I mean, it's right there. Well, the thing is, the scenarios can change, right? Based on the tenant.
That's not what's going to happen.
Okay.
When you go through a judicial process, just like when you go through a foreclosure process, which we're going to learn about next week. When the bank sends the notice, the friendly notice, and then the not friendly notice that starts the foreclosure process, the person's not just going to pick up and move. Because it's a judicial process, and they don't have to. And that's
They
why
don't
he's
have
not
to, but
worried at all.
in some cases it happened. It happened to me as a
But
landlord.
that's not what's going to happen here in Florida.
Okay.
Okay, so let's keep moving. So November 15th, we filed a complaint. You filed a complaint. And then what does that mean?
Filing a complaint is how you initiate a lawsuit. Okay, that's a lawsuit. Eviction cases are in county court normally, and you have to pay. You as the landlord have to pay a filing fee. For example, you're gonna have to pay.
How much is it?
It's $185. Plus you're gonna have to pay for each.
So let's write the $185 plus for what?
For each summons is another $10 per defendant. So each person who lives in the unit, each adult who lives in there, you're gonna pay an additional $10. There's actually some service charges on top of that too. So
how much is it about, you think?
you're probably looking at about $210, $215 in filing fees to the court, just to file your case.
Okay.
And you also have to pay either the sheriff or process server to serve the lawsuit, because you're gonna have to have it served by someone who has the authority to do it. You can't just hand them the lawsuit. They have to be served by somebody who's authorized to serve a lawsuit. That's gonna be another $40 per person. So if you've got two, maybe like another $80 for service charges.
So you're talking about 300 now?
We're up to about 300 already.
And you have to sue no matter what for an eviction process to proceed, right?
Right, this is, the cause of that, this is the only, our goal at this point.
Michael, use the mic.
Sorry.
Is it on? It might not be.
I think now it's, no.
Yes.
Okay, our goal at this point is to obtain possession. So yes, our lawsuit is gonna be, we're suing for possession. We're also gonna sue for the money damages, but, right now, our pressing goal is to get this guy out of there, because he's causing, we're losing money every minute.
Well, it's November 15th, and what was, on November, let's say this is a condo. On November 1st, the owner had to pay the condo fee, right? Could he say, I don't have to pay the condo fee because my client knew the rent was going to be late a week ago and he didn't pay it? Does he have to pay the mortgage? Yeah, so we're at November 15th, and we've got $0 coming in, and we have about 300 going out already. Okay? So what happens after the complaint?
Yeah, once the case is filed, give it a day or two for, the clerk. The court takes its sweet time sometimes. You've got to get the service of the lawsuit by the sheriff or process server. They have to try to locate the person individually, but if they're not there, if he's out in the club, they got to come back 6 hours later, and then they can post it at the door. So give a couple of days for that process to occur before the tenant's even been served with the lawsuit.
Maybe it'd be like the 21st, Monday the
Sure.
21st?
Yeah, easily, yeah. Okay. This is a realistic, is it possible to do these things sooner? Yeah, it is, but again, are you paying somebody to do it?
No, but we're in Miami-Dade County.
We're being realistic.
We're in Miami-Dade County, it's a very busy county, there's a lot of evictions.
Not if I do them.
Right,
if I do it, it's faster.
We're at November 21st, which is Thanksgiving week.
All right.
So maybe it won't even be Tuesday before they get it.
Yeah, of course, we're really slow this week. I can attest to that.
Let's say it's Tuesday, November 22nd, that it's served.
Okay.
Yeah.
Easily.
And then what happens after it's served?
When the service on an eviction case advises the tenant that they have 5 business days to file a response and either deposit the money that we claim is owed, the $1,000, the rent that's owed, or the tenant can file a motion with the court if they dispute the amount on the notice. So if they were served on the 22nd, which was yesterday, our 5 business days is only going to include today as the first day. It's not going to include tomorrow or Friday because those are both court holidays. Even Friday is a court holiday in Miami-Dade. So your 5 business days will include today, next Monday, Tuesday, Wednesday, and Thursday.
And Thursday is December 1st. What's supposed to happen on December 1st? So first we're going to say the 5 business days pass and we're at Thursday, December 1st. And now the Tommy has to reply or ask for a hearing or put his money in the court. So we'll put those, Tommy's replies to the complaint.
Right?
Yeah, put it under December 1st. And what else was supposed to happen on December 1st?
It's $2,300 in the hole.
What?
He's $2,300.
Do you think Tommy paid December 1st?
No.
So it's students.
Right.
Minus the 300.
Okay, so let's say now let's say he doesn't file his answer.
Okay.
Right.
So on the 2nd, if you're on top of it,
Friday.
you're asking the court to enter a default, which is basically a way of procedurally winning your case without having to argue.
And the landlord's asking for a default because since Tommy didn't reply, it's like playing in sports, I guess, kind of like he missed the pass, so now it just goes straight to default.
Right. The clerk will enter a default, meaning that he didn't do what he was supposed to do. This is only on the possession claim, by the way, not the money claim, but it's good enough. The clerk will enter a default, and then hopefully you'll get the file sent up to the judge to sign off on the eviction judgment. But that can take Depends, if the judge is sitting right there, you might get your judgment within a day or two. If the judge isn't, like what happened to me this past week and the judge was out for a week, I had to wait, over a week before the judge would sign off on the eviction judgment.
So let's say it's a week. Let's say it's December 9th. Friday, December 9th, the judge signs off on the eviction. And then what can happen?
And then once the judges sign off on the eviction judgment, the clerk will issue a writ of possession, which is the order that's going to be posted at the premises. That should happen.
They do it the same day?
If you walk it through, they will, but otherwise it might take another day or 2 or 3 before the clerk gets around to issuing the writ of possession.
So let's say our landlord, he has a lot of apartments. He doesn't have time just to be walking things through. So let's say that happens on like the 14th?
Sure.
13th?
Yeah, it could happen.
So it happens on, let's say Tuesday, December 13th, that the clerk
will issue the writ of possession, and again, the owner's going to have to pay another $115 in Miami-Dade. That's the sheriff's fee for a writ of possession. And that's for regular service, which normally takes about 2 or 3 weeks.
So let's say it's regular service.
Regular
service. 2 or 3 weeks. So we're at January 3rd.
Right, but remember the holidays, things get slow. I'm telling you, they do. They in years past, sometimes they've even shut down for like 2 weeks and said we're just not going to do any evictions. We're just holiday spirit. We're just not going to do it.
What about the speedy sheriffs?
You can pay an additional, as I did yesterday, an additional $1,195. Which is expensive. That's the sheriff's fee. And what the sheriff, I will tell you, this is a real example. I went yesterday, I was walking one through for a client. And so I brought it down to the sheriff's office, downtown Miami. We paid $1,000, my client paid an extra $1,195. They said, well, we'll post the writ of possession today, because they'll post it within 24 hours. And normally they would come back today. But because of the holiday, they've shut down evictions through actually until next Monday. So even the rush service, my client's not going to get possession until next Monday. So it's normally like a 2 or 3 day process on the rush service for an extra $11.95 instead of the $115. But it's really expensive, obviously. Other counties are different. In Florida, you might get an eviction under regular service within a couple of days or even a week, like in Broward.
Say that we're not on the rush service.
So it's 2 or 3 weeks. It took us into January, I think.
So I think we're at January 3rd.
Easily, yeah.
So January 3rd, which is a Tuesday, we're going to get...
Finally, the sheriff is going to come out. They'll have posted the writ, probably
But what was
before
supposed to happen on January 1st?
Rent.
Do you think you paid the rent?
No.
If your rent is due on stop. If your rent is due on a holiday, does that mean that you don't have to pay it by that date? No, it doesn't. No. Rent is still due by the date it's due, whether it's a holiday or not. Right. It's still late. So he doesn't. So January 3rd, we get the writ of possession from the sheriff.
Right. And that's possession. That's the sheriff coming out, knocking on the door.
So that means the sheriff's going to be there on the
Right.
3rd?
I would say that's reasonable.
Okay.
But what the sheriff does, remember, all the sheriff is going to do is knock on the door, and our buddy's still there. He will be removed. He'll be told it's time to go. But all of this stuff, if he hasn't planned any of this, because he hasn't done anything.
But doesn't he get 24 hours from that date?
It's probably realistic. It's probably already been posted, and they probably gave him a lot more than 24 hours. But they would typically come back within about 2 or 3 weeks. But you're right. It's the way it's supposed to work is they post it. It says if you're still here after 24 hours, you can be removed at that point by the sheriff.
So we think that would be January 3rd or January 4th?
We'll call it the 4th or 5th.
Okay,
sure.
Let's say January 5th, he gets removed by the sheriff. And that's a Thursday.
Right, but all that happens, and I just explain this to a client again, is the sheriff, if he's there and he's got so much stuff in there, or it's in, who knows what condition it is, all they're going to do is remove him and allow you to change the locks under the sheriff's supervision. So you're going to have to hire a locksmith to come out and be there whatever time the sheriff says, wait around if necessary, and change the locks. But anything that's still in there, any mess, any belongings, anything like that.
Why does the sheriff have to be there? Once the judge gives the default judgment, can't the owner just go in and take the place?
It has to be executed by a sheriff. Only the sheriff has the authority to do it.
Can't sometimes an owner do that?
No. And if you do that, you're going to run into 8367 that we talked about, okay? If you jump the gun, even if you already have an eviction judgment, and you go in there and you change the locks, you're not entitled at that point to possession. Your tenant is still allowed.
Why do you guys think, so excluding the friendly notice, the 3-day notice, the complaint, the 3-day notice says you didn't pay the rent and you're going to have to vacate. The complaint for eviction says you didn't pay the rent. The complaint for eviction gets served on the tenant so that he knows that he didn't pay the rent and that he's being sued. The default judgment he's also going to know about, right?
Right.
And then the writ of possession he's going to get a copy of. And then he's going to have something posted on his door that says you didn't pay the rent, you had a default judgment, you're going to have to leave. Why do you think there's all these notices in this process? Why is it due process? For what reason?
Protect the rights.
What right? But what is the right that Desi has?
Life, liberty, and property.
Right of possession.
He has a right of possession, right? And he has a leasehold interest. And the landlord is using the courts and the government, the judicial system, to take that stick away from him. They're taking his possession away. And we don't like seeing in the U.S. possession being taken away without due process. So we have a balance here because the landlord hasn't been paid rent now for 3 months. We don't know what kind of condition Desi's leaving it, or the Tommy the tenant, right? We don't know. Do you think it's ready to rent the next day?
No.
Could be, but probably not, right?
Who's going to haul out whatever's left in there?
Out of my
Or call hazmat?
And let's say that Tommy the tenant left stuff in there. Where do they put it?
Don't you have like 24 hours?
No. I mean, once the sheriff comes out, the landlord has a right to remove it, but it's at the owner's expense and effort, meaning you may have to hire somebody to move it out. You can put it beyond the property line. You can put it in the dumpster.
But then what if Tommy comes back and says that my stuff was ruined because the landlord moved it out?
If it's after an eviction, there's actually protection for landlords. He's going to be okay.
If Tommy left his stuff in there, he got all these notices, it went through the eviction with the sheriff, and then the landlord hired his crew to move the stuff out and just put it outside. What if it was raining?
Doesn't matter.
What if I had a garage?
In Maryland, if it's raining, they won't let you do the eviction.
That's nice.
Yeah, it's true. That is true. So there's different laws in different states. If it's below a certain temperature, I think in Maryland they don't let them do it. But it's the reason why it's really important to know the laws in your jurisdiction. So when do we think this place is ready to be re-rented?
February.
February 30th. Depends.
Maybe February 1, right?
Yeah.
So we're out for rent for November,
October.
December, January,
February.
right?
October.
October.
That was November.
No, November, you paid October, November, December, January.
February 1st also.
Maybe we'll be rented by February 1st, right? So we're out 3 months of rent. The landlord's had expenses, and is that the reason why the tenant didn't worry?
You could say this.
Especially when he got the friendly notice. Because he knew that the friendly notice didn't trigger statutorily anything.
Unless he was looking for another piece of property while the bidding process is going on.
He's not worried.
He's there to save some money.
Now, the other question, this is a default judgment where the tenant didn't reply to the complaint. So the tenant didn't reply to anything. But what if the tenant replies? What if he asks for a hearing?
Yes.
What if he has defenses? How much longer do you think it's going to go on?
I've seen
You're
years.
making me look bad, but it's true. But it can, and that's the
Then
reality.
the landlord gets really mad. He says, I want to turn off the utilities. This guy, he's going to be here for 6 months. He's up in the club. He knew the rent was going to be late. And he's just living there for free.
I have to explain this almost every day to clients. Yeah, I mean, and you can't do that. This is This is the downside. This is the not fun part of being a property owner or investor. Because if you do those things, then you're looking at somebody making a prohibited practices
Right, we
claim.
haven't talked about what's.
How much is for a landlord to file to answer, no, for a tenant to answer every?
Well, the tenant doesn't have to pay anything, but they're required to deposit the rent money that we claim is owed, or if they dispute it, explain the reasons why they dispute it.
And also, if they pay and you don't want to accept it, you need to pay the court $30, right, to put the money in court.
What you're referring to is that the tenant is required to deposit money in the court registry. Okay, if the tenant, if any money is deposited, there's a service charge on top of that the person depositing will have to pay.
So the idea,
typically it would be
right,
the tenant.
the idea was in this case, Tommy didn't do anything. He just didn't reply at all. But a tenant, the idea is that the law doesn't want to let a tenant like Tommy do what he did. So if a tenant has a defense, they'll say, okay, you didn't pay the landlord $1,000, pay it into the court. And then, once we get to your hearing, or once we get to look at your case, we'll decide who gets the money. But there's a little charge for the tenant to pay it into the court.
Right, and I think what you're referring to, if you accept money, you couldn't accept any money after a case was started. There was a change a couple of years ago that allows you in certain circumstances. But you're right, if you deposit as the landlord, you're going to have to pay a service charge. And if you get that money, if you succeed in your case in one form or another, the money is being released to you from the court charges another fee on top of that to take the money out. The court gets money, going in, coming out.
Yeah, question, Daniel.
I mean, there was something we sent us out to read about the pay to play. Does that
That's the
come into
pay to
effect?
play. That's the pay to play.
Right.
Oh, that's what it is?
And then you need to pay again to go after that money, damages and all that stuff.
Well, tell him who needs to pay to play.
You're talking about like pursuing a money judgment
No,
against?
the tenant needs to pay the money into the court.
Right, the idea is that if the tenant has a valid defense, if the tenant's going to say, I didn't pay my rent because my landlord wasn't doing all these things, for example, and I gave him a 7-day notice that we talked about somewhere in there, I had a real reason why I didn't pay it, okay? It's not that I went and spent it at the club and frittered it away on something else. The idea is that if the tenant has a legitimate defense, put it in the court registry so the court can decide whether the tenant was right or wrong. But the tenant has to put up that money.
Is it a defense that it was Thanksgiving and they were saving for Thanksgiving?
No.
Is it a defense that his girlfriend was pregnant?
No, but I've seen both of those.
Is it a defense that somebody got sick?
No.
So there's only certain things legally that can be a defense. The things that we believe should be a reason
I don't think I can
why
say this here.
maybe a court would say, okay, you don't have to pay the rent. Like, not because you have a lot of kids, not because it's Thanksgiving, not because it's Christmas, not because somebody got sick.
Right.
There's certain reasons that a court will accept, and which are they?
There's a long list of reasons why you might be justified.
You already paid the rent and the landlord didn't know?
Payment.
Right.
Payment is a defense. I tried to pay it, and the landlord wouldn't accept it. That's a good defense. It happens. And landlords will say, I just don't want this person. I don't want to accept any money. I just want them gone. You can't just do that. You have to. So, I paid. I tried to pay. If the landlord wasn't meeting their obligations under 8351, and the tenant sent that notice in advance saying these are the things that are wrong with my
What
apartment.
about I lost my job?
No, that's not a valid defense. Not a valid defense. I mean, retaliation. I called the code enforcement, and the landlord is now trying to evict me. That's a defense.
We were on a month-to-month lease, and would it still be this long process?
Process is going to be the same no matter what. Now, the initial reason is going to be different. Every eviction has to start with some sort of a termination notice, whether it's a 3-day notice, which is non-payment, whether it's a 7-day notice, which we didn't really talk about tonight. If the tenant's violating something else, like the tenant's selling drugs out of the unit, in other words, says, I don't want this person here anymore, they have to give a notice. You always have to advise somebody.
If the tenant's paying rent, but they're selling drugs, it's a non-monetary default because they're still current on the rent, right? But maybe the landlord, if the landlord is aware of it, they could also get in trouble. But let's say the landlord doesn't want to have that. I have this reading. from one of my prior students, hopefully I can find it, about his non-monetary defaults. He wrote, and he got the Malcolm Butters Scholarship. Do you guys know what that is?
Yes.
Yeah, this student actually got it. It's a $12,500 scholarship that's awarded at the end of the program. Two of them to the best students in online and live. So he wrote, he took over an apartment building. He wants to sell an apartment building. He only goes once a week, but his on-site maintenance man will call with issues that pop up and need his attention. He's always afraid he's going to get a bad call. He's only had one violent incident where some guest of a tenant got in a fight in an apartment and took it outside, and someone stabbed someone in the parking lot, and then came back in and trailed blood all over the hallway and up to the apartment door like a breadcrumb trail. The sheriff knocks on the door and asks the tenant if anyone was inside, as her door is covered in blood, and the tenant lies, and the sheriff comes in and they all go to jail. So does the lease end if people go to jail? No, it doesn't. They would still have, the landlord would still have to do an eviction. So they would still have to go through the process, even if everybody went to jail. So he had that happen. And then here's another one. When they took over, there was sex and drugs in the halls, and this had become a true hood property. Needless to say, where is this? Needless to say, I don't trust property management companies. I think there was this one. One second. Oh, after further investigation in interviewing the tenants, we discovered the property manager set up a prostitution ring on the first floor and didn't share the profits.
Didn't share the profits. Oh, but he didn't share the profits.
He did not share the profits, but even if he were to share the profits, it would be illegal. Here's another one. I once evicted someone because the pest control service we used said they couldn't spray because of the goat and other farm animals in the third floor apartment. Wow. He sent me a picture of the goat. Oh my God.
This is real?
So these are, having a goat in the apartment, the guy was still paying rent. And these people whose friends staff people in the parking lot, they were still paying rent. And we're going to see, we can talk about it quickly, having a goat in the apartment is one kind of reason, a non-monetary default, that you can evict someone if it says that you have to register the animals and you know, and no animals are permitted except if they're registered. And then another kind of default is the prostitution ring and the sex and drugs. Those are two different types of non-monetary defaults that the landlord can start the eviction process for to terminate the lease. And those things happen in real life. People make a lot of money owning hundreds of apartment units. But this is the type of thing as property managers, right, Sarah, that sometimes people have to deal with.
We had a close call with prostitution. Thank God it was not. It was speculation, and we heard rumors, and when we investigated, it was not. But we got scared because we are actually the owners of the property, so we got scared that we weren't going to be liable for anything. Thank God it was checked out. But I was scared because I didn't want to be associated with anything like that. But that's the risk that owners run into.
All of the things you mentioned, I've seen. Prostitution, I've seen all of it. Yeah. And it's all levels of properties.
Yeah, all levels.
It doesn't have to be.
This is a luxury home.
Often is, yeah.
In Parkland.
I believe
so
it.
The most unassuming homes.
So let's say that there are like the sex, drugs, prostitution. Does the landlord still have to go through this long process?
Yeah, pretty much. Yeah. And it's even more difficult because you have to prove your case. If it's not about rent, and the tenant is going to defend the case, rent cases are relatively straightforward, or should be. Either you paid or you didn't pay. It is what it is. But if you have an eviction for cause, you're going to have to prove what you're alleging. Just because you say or you suspect something is happening, and maybe you put it in a notice. But if you get in front of a judge, you have to have a trial over those things. It's not quite a criminal standard. It's not like beyond a reasonable doubt. It's more like preponderance of the evidence. It's just like more. The standard is lesser. We're not looking at a criminal conviction, but I have people all the time that complain to me and say, "There's drugs, there's this, there's that." They say, "Okay, I can pursue this eviction for you, but who's going to come to court with me? Do you have people who are going to testify? Do we have witnesses, exhibits, we have, the burden is on us to prove our case.
Right.
Say, everybody complains, but they don't want to go to court. They don't want to get involved. But all my tenants are complaining, but they don't want to do that. I said, well.
So that would be a different notice, because it's not a 3-day notice for non-payment of rent, right? Because the rent is current. It's called a 7-day notice, yeah.
Could you just call the cops and get them arrested?
Yeah, but if they're arrested, does that terminate their lease?
What if they're like locked up for or they die? Let's say they get killed in gunfire. Sorry for extreme, but let's say that happens.
If they die, the lease is terminated.
Yeah, it's terminated.
That's the only option.
Yes. It happens a lot more than you think. I'll tell you that. Yes, the lease will be terminated, but there's actually protection if you read in 8359. And nobody likes this. Nobody likes it at all. And I've had to do this far too much. It says here, okay, this is how a landlord can recover possession. And if we're looking at 3D, okay, the landlord shall not recover possession of a dwelling unit except, okay? I don't know if anybody wants to read this, or I can read it real quickly. When the last remaining tenant of a dwelling unit is deceased, personal property remains on the premises, rent is unpaid, at least 60 days have elapsed following the date of death, and the landlord has not been notified in writing of the existence of a probate estate or of the name and address of a personal representative. Okay, that means that if somebody dies and we don't hear from anybody and we don't have anybody to contact, technically, the landlord can't recover possession until 60 days have elapsed. Okay? So, huge burden on the landlord who's not getting paid rent. I'm not sure who's going to complain in these situations, but, the way that's written.
There was a case I knew about in Maryland where a man was a tenant and he lived with his girlfriend and he died, but she wasn't on the lease. And then the wife said the stuff was hers. And the wife wasn't on the lease because he didn't live with her. So the landlord didn't know who to let in because the wife wasn't on the lease and the girlfriend wasn't on the lease, although she lived there. So it gets complicated for them. I have another question. Does a landlord have to an employer has to verify whether somebody is authorized to be in the U.S., or whether they have a green card, or whether they're a U.S. citizen? Does a landlord have to do that?
No. Not at all.
The landlord doesn't have to do that, at least not now, right?
Right.
And then, does a landlord, if a landlord's tenant is deported, does that terminate the lease?
Not technically.
Did it terminate my lease when my tenant was deported?
Wow.
My tenant was deported. He's a very elegant man from Mexico, and he had more shoes than me. But he was deported, and he was kind enough, he was kind enough to send me an email and tell me what happened. And what I did, because I knew his lease still was in effect, right? I asked him to email me. I said, could you please email me back if you're giving me back the right of possession? And he said, I'm giving you back the right of possession. And then he also had a friend give me the keys. So I was able to officially have something that he said, you have the right of possession. Because otherwise, the fact he was deported technically wouldn't terminate the lease.
Right, and if you had gone in there and changed the locks,
right,
and and suddenly he comes back, finds his way back in, he's now suing you for
on the lease though. You can't put that on the lease. Must be a citizen or if
you can't.
I think you'd run into discrimination.
If you're not a citizen, like if you're here illegally.
Listen, you cannot put on the lease. What are the protected classes? They're race.
Hang on, I think we even have a slide on this maybe.
Yeah.
I mean there's different fair housing statutes. For example, the Federal Fair Housing Act, which is the first one listed there, protects people on the basis of race, color, national origin, religion, sex, familial status, and handicap.
Even illegals? If you're illegal?
Well, now here's the thing.
You can't say that I won't rent, and I know this because after this happened, and then on top of it, my condo association would only let me rent once per calendar year, so I had to leave the place vacant until the calendar year changed. So I would prefer to rent to someone who has a legal status in the U.S. But I'm not saying, I don't care what country you're from, but I want to make sure that you're allowed to be here just so you don't get deported.
Right, and I mean, at the same time, I don't want to turn.
I would put it in writing.
Well, I think you may, if you do that, especially in South Florida, depending on where you are, you may run into one of these issues. Not that you're intentionally saying, I'm going to discriminate against somebody because they're from this country, but national origin, that category can often be used as a cover for those things. So I would be very careful about that. And I don't want to turn managers and property owners into you're not the police. It's not your job to deport people. It's not your job to report people to INS.
You can still get paid from your tenants that are non-US.
Right, so do you have to have it in?
You don't get in trouble for that?
No,
Okay.
You get in trouble for that at all?
no, not right now.
No.
We'll see what happens
Yeah.
after January 27th.
I mean, it's different in the employment context, which is I think what a lot of us are thinking about, where you're employing somebody and you know that they're not legal here legally. But for housing, I would be very careful, particularly about running into, fair housing claims are real. I just got another client just got another one
And can
yesterday.
somebody do a fair housing claim even if they're not a U.S. citizen?
Absolutely.
So somebody asked me, do the Florida statutes protect non-U.S. citizens? The answer is yes, they
Absolutely.
What about non-residents?
do. Yes.
Yeah, I mean, there's hard to believe, but even if you're not here legally, you still have certain rights in this country.
It's
in
in the
It could change, but for the
I have a
moment,
question.
that's what it means.
In chapter 83.59, it states that the landlord is entitled to the summary procedure provided in chapter 51,
Yeah.
.011, but I can't find it in.
It's not in here. If 51.011 is a summary procedure statute, what that means is that landlord-tenant cases.
In the Florida statute.
Yeah. It's eviction cases.
So now we know, but this
Okay.
is part of now we know it's really easy to find statutes. I think it's sent to it, but you can just Google search Florida statutes and that number, you can find it. Yeah.
What it is, and when you look it up, you'll find that it's the summary procedure statute. It's certain cases are designed to move quickly through the courts, because courts are notoriously slow. We've already seen, these are supposed to be fast, okay? Evictions are go on a fast track. They're supposed to be over in weeks or months. Like small claims cases are also under summary procedure. So if you file, if small claims are monetary claims up to $5,000 that you can file on your own, or if it's the things you see on TV, Judge Judy, those kind of cases, they're designed to move quickly. So landlord-tenant cases, residential cases, are designed to move quickly through the courts. But as you can see, even this quick process can still take a couple of months. But that's what 51011. It limits, from a lawyer's perspective, there are certain things that you're not supposed to go through, like, discovery. There's all these things that you're not supposed to do. It's supposed to be quick.
Yeah.
If I was the landlord of Tommy, tenant, I would just do the same thing you did. I said, okay, if you want to avoid this entire process, and I want to avoid this entire process, why don't you just email
Well, and
me
that's,
the
I think that's what we might have been getting to with the friendly notice. Sometimes, there's a few things landlords do. Sometimes landlords, they actually pay someone to move. They say, you know what, I'll give you $200, we'll terminate the lease, get out of here. You won't have an eviction on your record, I won't have to deal with this. But the tenant could say, I don't care because I can stay for a while. Some tenants know that game. Some tenants do, and some tenants don't. Some tenants get that 3-day notice and really think they have to move out in 3 days. Adela.
And what about if you have an international rentee?
No change.
All this process.
Absolutely.
And if they are not here, how you?
Well, mine wasn't here, but he emailed me.
Yeah, in the case that you are the landlord and then you want them out of the property, and they are not here, but they still have the key or whatever.
The only thing that will help, you still have to go through this process, okay? The only thing that will help you, and in 8359, there's another provision in there, okay, that ultimately would have helped us if we had gotten to that point in this case.
Abandonment.
The abandonment. That says it's basically 8359 3C, where it says when the tenant has abandoned the dwelling unit. If we know that they've abandoned it, we may be able to retake possession. But there's a presumption in the law, and they changed this a little bit a few years ago, but it says, in the absence of actual knowledge of abandonment, it shall be presumed that the tenant has abandoned the dwelling unit if he or she is absent from the premises for a period of time equal to 1/2 the time for periodic rental payments. However, this presumption does not apply if the rent is current or the tenant has notified the landlord in writing of an intended absence. that one is kind of legalese, but what that means is that if the tenant pays rent monthly, okay, and they've been gone for 1/2 that period, so 15 days, okay, they're just gone and they owe rent and they haven't given like a notice saying, hey, I'm just going on vacation, but I'm coming back in a couple of weeks, I'm still living here.
Okay.
You can presume that the unit is abandoned, and the landlord at that point, once you've documented that, and I always tell my clients, make sure you've documented 15 days. You want to be really sure about this. At that point, the landlord has a legal right to retake possession. But what you don't want, and what I've run into over the years, is where a landlord thinks somebody's gone, or hopes somebody's gone, but they've been coming back and forth, or somebody's seen them at the property, and the landlord jumps the gun. Again, if you do that, now you're in a prohibited practice. You're in an 8367. So I tell my clients, I'm like, I love abandonment, but be confident that the tenant truly has abandoned the property. If you're going to avoid this process, okay, so that's basically forgetting the courts or not finishing your case and not having to pay all that money, you better be really, really sure that the tenant is gone.
Question, Danny.
Quick question about the eviction process. Let's say the tenant gives the landlord not the full lump sum of the rental payments that have basically accrued up until January 3rd, and he pays like a small monetary consideration fee. Will that eviction process start from that point on all over again?
Not necessarily. It used to be that the landlord couldn't accept any money once it started. Okay, there was a change in the law from about two years ago that allows the landlord to accept a partial payment and to keep moving forward. But you may run into a situation with a judge if you're continuing to accept rent payments. Again, think about what's going to be reasonable. Is a judge going to, again, we're speaking hypothetically. Now you've got a dispute. You've got a tenant who's made some payment or some payments. Is the judge going to sign off on that eviction judgment? Maybe not.
Threshold of like.
There's not a specific threshold. Okay, so that's why. Generally my advice is after you file the eviction, you shouldn't be accepting any more money. Even if you're allowed to now do it under the law, I think it's a bad idea. If you're going to pursue eviction, if you want to accept payments, this is my recommendation to my clients, and we do this all the time. Let's enter into a settlement agreement allowing you to accept payments, but establishes very specific deadlines and a specific payment schedule, so if the tenant doesn't meet that, we can move forward with the eviction and we can keep it open. It's all a stipulation that we're going to file with the court. It's like a written settlement agreement with the parties. It's going to have the authority now of the court. So we may come to an agreement with Tommy at some point in here. We're like, okay, fine, we'll get some money. We'll put him on a payment plan, get him back on track, give him a couple of months to pay. And then when we get to January 1st, when he misses his payment, instead of starting this process all over again, all we're doing is, I'm filling out an affidavit, giving it to the judge signing a judgment, and we're picking the case up from the end. So that's an option too, and something that's where you can really benefit, I think, from having an attorney who can help you at that point.
Why do you guys think that, sometimes people go get a mortgage for residential property, multifamily property, and the lender says they want to include a 5 or 10% vacancy rate, even though the units are filled? Why do you think that is?
Cover that period of time.
Yeah, because it happens. This is one of the things that happens with landlord tenant, right? Yeah. Do you have a question?
Oh, when the lease ends and the landlord doesn't want to renew the contract, however, the tenant doesn't want to leave, you still have to go through the eviction process.
You may. I mean, it's going to depend on what the lease says about what kind of notice is required at the end. If either party is supposed to notify the other party what their intent is going to be.
But by law, you don't, by Florida law, you don't have to, the landlord doesn't have to provide a notice at the end of the tenancy unless they say that they will.
Right.
And if they say that they will, then they have to. If you hold over, that's what it's called, a tenant who stays in possession. Let's say, Sarah rents an apartment to you, and then your lease is over. So she has another tenant who's going to pay more rent, but her grandma wants to move in. Whatever the reason is, it's her property, right? And you have possession, but you only have that possession for a limited amount of time. and now you're holding over. So she can send you a notice that you're gonna have to, or if you say in the lease, a holdover tenant's gonna pay 2 times the amount of rent, and then she's gonna have to start the eviction process though.
Yeah, I do.
How much does it cost to use an attorney for these things, more or less?
It depends. I mean, I know a few years ago there were like, attorneys that were charging like $99. Usually, you get what you pay for. Usually, you're looking at least about $500, I would say, for an eviction, depending on, if you're,
And if it goes all the way through, that's it?
Probably more, but it depends. 1,500 easily. Yeah.
Including the fees, right?
No, not including the
Not including that. That's the attorney. That's what I get. On a case. That's what I'm getting, and I'm getting paid that up front probably, because I don't want to risk not getting paid. So.
Yes. Quick question on the defenses for the tenants. So I'm in a situation right now where I have a tenant that wants to release the lease because she's claiming that she's now mentally unstable and that she was not mentally stable at the point of signing the lease. And I don't know what to do.
Yeah, I've encountered those claims over the years.
I've acquired advice from my attorney, but I don't know.
How long has she been?
6 months. And she's been paying.
I mean, it's entirely the facts of your case.
That's though?
No.
It really isn't.
You need to be mentally stable to enter into a contract, but I don't think the facts of that case don't sound right to me, but those are questions you can ask Michael afterwards. I
just wanted to know if mental instability was a defense.
No.
It's not a recognized defense. I mean, if you're alleging that, there was something, like it's some kind of a fraudulent inducement or somebody took advantage of you at the beginning, that's something separate from even evictions. But, I mean, it may...
That would invalidate a contract.
It would invalidate a contract.
Meeting of the minds,
Right.
one of the minds.
Right.
What does that sound?
Right.
In that case, the tenant is still owing like 3,500.
Yeah.
So how do you go after that? Is it cost effective?
Well, we can pursue a money judgment. You can pay me, or you can do it yourself. You can go through the process. It works kind of concurrently, but there's a little bit longer deadline because it's not under the summary procedure statute. You can get a money judgment. That's all well and good. A court will eventually give you a money judgment. It costs you more time and money to get it. And then the problem in Florida is collecting on a money judgment. Getting money judgments is the easy part. It's getting them to pay. If you've got somebody who's, a slippery character, to say the least, or somebody that's, difficult to find, or if you don't have, maybe people disappear. That's, people have common names and they disappear and it's hard to track them down, or they've got nothing. Yeah, you may be able to apply the security deposit. You should still follow, there's rules.
You have to send a notice, even if you evicted the tenants, you have to send them a notice?
You technically don't if they haven't fulfilled their lease terms. There's a waiver for the landlord unless the tenant gave you written notice in advance of their new address. But my recommendation is to always send that notice. We didn't talk about security deposits tonight. It's probably the most important thing we didn't talk about.
But you guys can, the security deposit is very,
just read it, 8349.
8349. And it says exactly what the landlord has to do in the language. Yeah.
When you charge, would you say, hey, I charge a fee plus a certain percentage of all the money that I collect?
Would I do that? I've done that.
I mean, yeah, sure, if it's a big tenant.
Absolutely, yeah. I mean, I'll take on collection matters. Sure.
I think, I have my little apartment, but then he represents some places that have 200 apartments or 500 apartments. Right.
I have different.
Right.
I have different deals with different clients. But yeah, and I generally don't work on on contingency just because I'm just not. It's not my focus. I'm not. It's just not what I do. I like to just get paid and do my work, and if I recover it, fantastic,
Yeah.
But I think it creates a weird set of conflicts, but that's just how I do things. Because then I have a real interest in getting it done.
Is there any law against intimidation? Because I was reading about President-elect, and he was giving a story about that when he used to have properties in New York, him and his dad. You just show up and you have your handgun on your hip and you're asking for your rent, but you're not Say
I
use
think
it.
that would run into a lot of problems with that.
But maybe not in New York, but I'm sure in New York too. I mean, we're talking about Florida, not law tonight, but I think in New York it would be too.
And a federal lawsuit over there.
Yeah.
Oh, wow.
Federal. Anitra.
If you start this process and let's say it's not the minimum 1 month, 1 month and a half, it takes you 6 months. And can you compromise in the middle of the...
With who?
Let's say the tenant wants to pay you for the amount he owed you, and then go.
Sure, you can make it.
Stop this process, right?
Absolutely. Yeah, I mean, you can settle a case at any point, typically. And it happens. I've settled a case as I'm typing it up, to file it, and when the sheriff is knocking at the door, we've settled cases, depending on where we are. And, there's no waiver, you want to move quickly, like in this example, the landlord got going within a couple of days or a week or so of when rent was due. But if you wait, I get cases all the time where landlords, it's sometimes gone months where the tenant hasn't paid, and the tenant's made promises or maybe a small payment here and there, and there's you're not going to waive it on time in that situation.
And this process, to make it clear, is only for the possession, not the money.
Yeah.
This is only for possession, what we were talking about, right?
When you start the process, after it finishes the possession,
it runs kind of concurrently, like, when we talked about that 5-day deadline,
yes.
In that situation, for the money part, the tenant actually has 20 days, which is like almost all of their court cases. You get 20 days to respond. So it kind of moves along at the same time, but it's treated a little bit differently. For example, when you're serving them, when you're having the sheriff or a process server come out, you can get possession just by service by posting. So if the sheriff comes out and nobody's there, they come back again 6 hours later, they can post it. But if you're trying to get a money judgment, they've got to hand deliver it to an adult at the premises. So it works similar, but it's going to be a little bit longer. And again, I have most of my clients, truthfully, choose not to pursue money judgments.
And you say, like, why the client use an attorney, right? A lot of the clients, their business, well, two things. Either their business is renting apartments and maintaining the property, and maybe they're also investors, and that's what they do. They don't want to go into the court and file all these notices and know the special words to use. They just want to get it done. And the other type of person may be somebody like Lloyd, who visited class. He has a full-time job, right? And he's an investor. He owns a couple of properties, and during the week he's working here. So he can't do all those things himself. Right.
So,
I mean,
yeah.
Like, it would basically cost if they were to do that, pay concurrently, it would charge him, it would cost him double, to serve, to do the entire, to pursue both the money.
It could. It doesn't have to, but it might cost. It will cost generally more. I'm going to charge more for pursuing this because this is a lot more work for me to get. To get the money judgment. I've got to go to court, and and I'm going to make sure I get paid because I'm not sure they're going to get paid. So, yeah.
So, well, thank you to Michael. We're going to
keep talking.
No, and also we have to go over, a lot of people did not do the commercial leasing assignment, which is fine because it's optional, but I want to go over the answers so that we don't get too backed up. And we're going to take our class photo.
Everybody, if you want, actually,
To have some makeup on. All right, Michael, here's your gift. Thank you.
Thank you very much.
You're welcome. And we're going to take our class photo over here because we have the FIU sign in the background.
The easy row. Which one? For number 10, the printing, or? Number 4. Number. Is that before I did number?
I would say this is a mic here.
Who's
going to take the photo?
And she's going to come in. Yeah. We're going to switch out. Yeah.
Come on. He's a cartoon model.
We can could do one serious and one.
Yeah, you wanna go to the front? Yeah.
Okay, here we go.
1, 2, 3. Okay,
Crazy.
1, 2, 3.
You want to be in one?
Oh, good, yeah.
Okay, good.
No, the first thing.
You're looking good today.
Yeah, I know.
You're stuck.
You guys are definitely
I'm gonna start going over us because our recording ends at 10. That's the thing. Okay, you guys can forget Michael's. I'll send out this information if you want me to. You
I can see that.
Okay, I'm going to start reviewing the commercial leases assignment. I know it was a lot to complete because you also had a midterm, but the commercial leases class, just like this class, was very complicated, and the assignment really reinforces what we learned. So this one says, explain 3 of the landlord's main concerns when leasing space out. So this person wrote, ability to pay. It is really important to determine whether or not this tenant has a good or faulty credit. A minimum score of credit is 580. The landlord is trying to determine from this the debt coverage ratio, roughly. Thank you, Michael. Bye.
Thank you.
I'll send it out, so thank you so much. Have a good flight. Yeah.
Happy Thanksgiving.
Happy Thanksgiving.
It was a pleasure.
Bye.
Good luck, everybody.
The debt service coverage ratio, roughly 1.25. If a tenant will not default on monthly rental payments and can show that there's additional revenue. Tenant profile. In commercial leasing, the landlord's greatest concern is maximizing income streams. In order for the landlord's operations to be at full optimization, it is futile for the landlord to understand, it's necessary, not futile.
I know, I didn't proofread.
You have to proofread it. For the landlords to understand this business, clientele, and management that will attempt to take up a parcel. If the landlord recognizes that he or she will benefit from the arrangement, then the parties will go their separate ways. Pay-to-play agreement. In the case that the tenant were to default and an eviction were in order, the process is normally very time-consuming and can cause hiccups in the income streams. Predominantly because the tenant can normally stay in the space it is operating without paying rent. However, this agreement impedes that possible scenario by forcing the tenant to continue paying a fraction of the rent throughout the eviction process, unless the tenant decides to pay damages and leave immediately. So, I don't care which ones you choose. I just want you to think, like, if you were a tenant or if you were a landlord, what would you think is important, right? So this one says that this landlord would care about how the property is being used, for what purpose. If the lease doesn't specifically indicate certain areas that are forbidden to be used by a tenant, could it be for any legal purpose? If the landlord will be paid on time, and if the tenant will cooperate with other tenants, for example, in a shopping center, providing a smooth coexistence with different businesses. So you can choose any ones you want, but I just wanted you to get your mindset around if you were a landlord, or conversely, if you were a tenant, what would be important to you. So explain 3 of the tenant's main concerns when leasing space from a landlord. It says, as discussed in class, the tenant's main concern when leasing space from a landlord include having a long-term lease with no rental increase, thus ensuring business in the space, And remember, we're talking about commercial leasing, so it's different because residential leases are normally just a year. Not being wiped out from the space, for example, if the landlord stops paying the mortgage by default. And having a good relationship with the landlord for the period that the lease lasts. So, I like that one. I like this one. This is the same thing. It says the lease term and the payment dates. The subordination on disturbance agreement, which is the same idea, making sure that the tenant's leasehold interest won't be wiped out if the landlord stops paying the lender, especially if they've made improvements or built out the space or built goodwill, like Pedro had said, and rent roll analysis. So it's okay with me, you don't have to choose the same things as someone else, but you have to show me that you thought about it and that there was a reason that you chose it. Let's see. Let me see this. I had here we go. Telling the tenant. Identify the important dates in the lease discussed in class. Are these dates memorialized? If so, where and why? Explain what timers of the essence means. Are those words included in the lease we discussed in class? If so, where? The first important date is the commencement date of the lease, which is November 1st, 2008. It is memorialized on the first page in Exhibit E, Section 1.1b and Section 2.2. Also, we covered the lease expiration date, which is shown in Exhibit E and Section 1.1c. As our guest lecturer stated in class, time is of the essence means that dates on a contract are strictly enforced, and failure to meet any time frame in a contract is considered a breach of contract. Our guest lecturer also stated that it's important to include this because tenants have tried to argue that they didn't know the landlord was serious with the date, or that it was strictly enforced, or that they were on Miami time, or that they just missed turning in their exam by a couple hours. Right. Time is of the essence was mentioned in section 2.3.3 and page 8, and in section 17.25 on page 36. So this answer is super good because it gives me some dates. Well, it gives me the commencement date, but we also talked about some other dates. And what I like about this answer is that it specifically refers to sections of the lease, but it doesn't give me all the dates that I was looking for. So, let's see. Looking for, let's see if this one does. The date of the lease, the rent commencement date, as we see it's stated in 1.1, page 12, and also in 4.1, page 12. Additional rent late payments. What I was looking for are, the lease execution date, the lease commencement date, the possession date, and the rent commencement date. Because in this lease, they were all the same, but it could be different. And it's really important to know that you're looking for these dates in leases, especially if you're doing lease analysis or lease abstracts, because the days are really important. And what I like about these answers I'm choosing is that they're very specific. It took time to write an answer like this, right? I saw an exam quickly. I didn't look at exams yet, but I saw one quickly that gave me like one-liners to all my questions. And one-liners don't answer the question specifically, and they don't compete with your other colleagues who are doing answers like this. It doesn't show time invested, right? It doesn't show spending time with the documents. And a lot about this class is learning how to read, right? I'm pushing you to read these statutes, to read these leases. That's a hard thing because most people here are numbers people. But I want you to gain that skill of, even if you don't know what it means, to start to get into reading it and know enough to ask a question when you hire a lawyer. So you're not just not knowing anything. Let's see. Explain how you see or don't see the lender's influence in the commercial lease discussed in class. Identify the specific provisions. I think the lender's influence in the commercial lease discussed in class is not good. Neither is it fair for the tenant. This is evident in 17.18 mortgage approval, page 35 of the lease, as is stated clearly that the landlord may terminate the lease if the tenant does not agree with any changes imposed by the lender. I think, therefore, that the tenant shouldn't have signed such a lease as it could violate his interests. Instead, he should have negotiated this section because the law assumes that people in business know their rights. Overall, the tenant probably did not read the whole lease before signing it. Probably true. Let's see, I'm gonna look at, because there were some other places that the lender was involved in this lease. Let's see. So this one says, in any and every lease, the lenders normally require certain warranties and assurances, such as due on sale clause, acceleration clause, or subordination clause, which all these clauses protect the lender from mortgage default. In this particular case, we see it on section 11.3 on page 26, that the lender has a right to the subordination clause. The subordination clause will give the mortgager's loan priority over any other loan. Also in 17.8 on page 35. And then I asked, do you think that the lender is going to read the leases even if they're long, and printing them might kill trees? This person wrote, moreover, for reasons as one stated above, the lender is definitely going to read through the lease. It's very important to understand all the provisions and confirm that there are there for the mortgagee as well. Without carefully going through the lease, the lender can accidentally omit something and not hold the mortgagee liable. Identify who may consider the three words and or assigns dangerous, like the scream, piece of art, if they are placed after the tenant's name in a lease. Explain why. When the three words and or assigns are placed after the buyer or tenant's name in a contract, it generally amplifies the current, I would say the current buyer or the current tenant who can lease the property. It now allows no, this isn't right. We're talking about owners in this. No. It's the owner who should be concerned because it's meaning that the owner thinks that they're leasing to tenant A, but it's allowing tenant A to assign to anybody. So they could just put anybody in there. So the owner's the one who should be assigned, who should be scared. So here it says, the landlord finds the three words and or assigned scary because the tenant passes his responsibilities to the landlord. For example, while the landlord may have already checked the tenant's background and his or her credibility, with these three words and or assigned, the tenant has a right to add his or her assignee. This is apparently something that the landlord wouldn't like to happen because they can't control who's in the building, right? So you might want to have, if it just says and or assigns and it doesn't limit how the landlord credentials and assign, it could really open it up to the whole world of who could take the tenant's place, right? Question? No. Explain why a landlord may care or not care who the tenant is, whose space is at the door, even if all the provisions of the lease are being upheld in the following context: a single tenant building, an office building, and a shopping center. 6. The landlord cares who the tenant is, whose space is at the door, even if all the provisions of the lease are being upheld, because a lease is not a purchase contract. Instead, it separates ownership from possession. In this regard, a lease is the beginning of a relationship between the landlord and the tenant, and therefore the landlord needs to protect his property. In the context of a single tenant building, a landlord cares who the tenant is because he wants to know if the tenant is the same person that signed the lease, if the tenant is creditworthy and therefore can pay the rent on time, as well as what kind of use of the space and whether the tenant has a family, pets, etc. It doesn't matter to the landlord in commercial if the tenant has a family. They might not want to have, like, let's say they thought they rented it to a Starbucks and then it becomes a pet grooming shop. They might not want that kind of use there. So it's more the use, not as much the family. In the context of an office building, in addition to the above concerns, a landlord cares who occupies the premises because he wants to know the nature of the business, office, and therefore avoid heavy users that might cause damages to the space, like secretarial schools, employment agencies, post offices, banks, etc., that bring too much traffic and wear and tear on the common areas of the building, like the parking or the elevators, hallways. Finally, in the context of a shopping center, a landlord cares whose space is at the door because in addition to the concerns above, he wants to know whether the tenant will have a profitable business or can easily collaborate with other tenants in the shopping center. And I think I only have 2 minutes before the recording goes off, so I want to say a little bit about the midterms. When I was in college, I wrote a great paper on permafrost, and it was about like tundra in the Soviet Union. I thought it was wonderful. But I didn't spell check it, and I wrote permasoft through the whole paper, which is a type of shampoo. So my professor he gave me like a B+ instead of an A. He said, you did a great paper, but you didn't spell check your paper. So it made me follow directions and spell check much more because my grade took a little bump because of it. So in this class, part of this class is learning, especially with law, to meet deadlines. And there were 2 reasons that I said to submit via Turnitin. One was to meet the deadline, and the second is because Turnitin has a way that I can grade and give you comments directly on your electronic paper that you can see without me printing, scanning, handwriting, all those things. So people who turned in late missed the deadline, and also put me at the printing, scanning, all these things for me to give you comments back. So that's the reason why if you turned in late, your grade will be reduced a certain amount. I haven't read them all yet. The answers that will get the most credit are the ones that refer specifically to our readings to support their arguments. I'm sure we've gone over all the answers together. It was open book, so I'm sure many people did well. And we have a final coming up. So this is not the end of the world if you didn't earn an A on it. I don't know what anybody earned yet because I've been busy preparing. We just came off the developer lunch and I've been following up with everybody. I had class with 80 other people on Monday night. So I haven't read them yet, but I'm going to give people comments directly on your paper. You might not figure out how to read them, so I would call IT because you're going to have comments like on your electronic paper that you can read. So that's that about the exam. So there's a chance, for everybody to turn it in the final on time. A lot of the people that didn't turn it in on time or didn't turn it in never did a study question, so they couldn't figure out how to use turn it in. So that's part of the thing. Like the study questions kind of train you for the time period and the way to submit. So with that, next week we're doing foreclosures. It's a lot of legal reading again. We're going to review the rest of these questions. We're going to have landlord-tenant questions. Before, I guess everybody was here, I said, and I'll send you an email about it. You don't have to, but I'd like you to watch The Big Short before our next class. And we'll have study questions that go along with The Big Short. They're optional. They're just kind of to focus you on what happened. So it's like, who was Brad Pitt? And who did he play in the movie? And why did he tell the guys not to celebrate at the end? So, it's good, fun questions that you can just print them and do them while you're watching the movie. You don't have to watch the movie. I had a link to the movie, but it was like a free link, and then they shut it down. So I would, if you want to watch it, it's on Netflix. Yeah, I didn't know if everybody has Netflix, so I don't know. Yeah.
Is it possible to have the presentation of?
Yes, I will send Michael's presentation. I will send his contact information. He's a great attorney and he's very reasonable. And if you contact him and it's really something he believes that you could do yourself, he's not going to charge you an arm and a leg or probably walk you through how to do it. And if it's something that you need representation for, he's very reasonable. He has his own firm. And he's been doing it for 16 years, right? Both sides, landlord and tenant. So he knows the defenses that tenants put up that work or don't work. So with that, thank you. Happy Thanksgiving.